statute. And in recognizing that the court was to interpret existing law at that point, the legislature then had to craft additional statute or revise that statute to allow for victims or witnesses or third parties to be to introduce expert testimony of battered woman syndrome. So I think what we're confined here and what we're certainly asking the court to do is interpret existing law in the event that that the state of Ohio wants to go further, then we would ask the General Assembly to address that.
Well, are we talking about a rule of evidence, or what are we talking about here?
I think that my understanding is we're speaking of the statutes that are in effect.
No, I'm asking you, what's this case about? Is it a rule of evidence?
This case here?
Yes.
This case is about many things. It is about rules of evidence, and
right.
those rules of evidence are 403.
And doesn't this court adopt rules of evidence?
Correct. This honorable court can certainly interpret rules of evidence.
All right. And has the General Assembly preempted here with their statute? Do they?
I think it is preempted in part, not necessarily in rules of evidence. I'm sorry?
Do they say that?
No, there is no limiting language
right.
per se of the statute or this decision in costs. But I think the implications and the following of all the cases around the state would show that courts of appellate jurisdictions throughout have utilized costs in the statute for limiting purposes. So, thank you.
Thank you, Mr. Friedman. More than 1 minute.
Honors, I disagree respectfully with the appellee's assertion that that the doctor offered only general information, and I would just point the court's attention to page 530 and 531 of the transcript, just to show one of the points of specific determinations in this case by the doctor. I would also, in close, address the fact that the cycle of battered woman syndrome would not have been met had considerations of conduct which was only charged and not convicted been utilized to make that determination. Lenore Walker states you need 2 cycles. The Dr. Eisenberg stated it could be 3 cycles, and here we only have 1 domestic violence. So the only way we can get there is if we're considering what's been indicted, and what we then do is discard the presumption of innocence. Credibility is always an issue upon cross-examination. And as a result of this case, what we've done is we've opened up the floodgate to rehabilitate, if we are affirming the decision, opening the floodgate to rehabilitate any witness or victim's testimony that's full of inconsistencies or where they are simply caught in a lie. You
need to sum up, Mr. Friedman, here.
I'm sorry?
You need to sum up.
Very good. Thank you.
What would the lie be here?
I'm sorry?
What would the lie be that she was caught in?
Well, I think that the precedent here, I don't necessarily, I'm not making an allegation that there was per se a lie, but if we are extending these holdings and allowing an expert to come in, what we're doing is, in effect, when someone comes in, they can simply tell a doctor, yes, there's been a history, and then after cross-examination by a defense lawyer to seek or to determine whether credibility exists, we're now allowing for a doctor to come in and state, yes, it was inconsistent, however, this syndrome explains all of that, and that's improper. To sum this up...
What was inconsistent? I'm having trouble understanding you here.
Well, I think the inconsistencies or the problems that the jury would have to consider for purposes of credibility were, as counsel for the appellee stated, that the victim did not leave, the victim could have left, the victim did not report any of the matters, all of these types of things. Lies to the doctor, lies to co-workers. So there were specific lies acknowledged by the victim at trial, yet cleaned up under the guise of battered woman syndrome. In this case, the appellant was unduly prejudiced, cannot be seen as harmless error, and Mr. Haines is deserving of a new trial. Thank the court for its time.
Thank you. The case is submitted. You'll be advised of our